pen down judgment in Baltic Europe Limited and Health and Safety Executive.
For the reasons set out in the draft judgment, copies of which have been supplied to the parties, the appeal on counts 1 and 2 was successful to a limited extent. The appeal on count 3 was dismissed. Costs will be dealt with separately in accordance with the direction already given to the parties.
Appeal in the matter of Kuteh and Dartford and Gravesham National Health Trust.
Yes. Mr. Diamond.
My Lord, I represent Mr. Kuteh on
Yes.
this appeal, and my learned friend, Mr. Ajay, represents
Yes.
the NHS Trust. Religion, described by one Supreme Court judge as a tenet of faith for many and the rankest error for others. But in spite of all its controversy, it's deemed essential to enlightened opinion and good conduct. And the famous Jewish philosopher, Maurice Mandelson, he said, the state has physical power and uses it when necessary. The power of religion is love and beneficence. My Lord, this is a case that's not to be miscategorized. It will involve discussion of the place of religion in the workplace. And religious rights in the workplace manifest themselves in multifarious manners, from a refusal to obey an order, perhaps to work on a Sunday, to a conscience violation, perhaps in relation to marriage counsellors that relate, and to this case, speaking religiously in the workplace. But I think it's very important that this case is put in context. It's a case about a wrong test by an employment judge. A wrong test because the significance of Article 9 is simply not being fully recognised by the employment tribunals, and there's been a number of EAT decisions which have neither appreciated it or have not needed to directly confront the role of Article 9 and the influence of the decision of Ed Weider. But what this case is not about is about the right to say whatever you want in the workplace. What the case is not about is that employers have no rights. It's a case on the balance of rights. And I would just say I submitted a supplemental skeleton argument.
We read it, thank you very much.
Yes, I took that as a slight hint from the bench, I ought to say, but my learned friend may have an objection to it. I don't know whether he does.
My Lord, I don't object to it. I just note that it is late.
Yes.
And without permission, I think my learned friend misunderstood the communication from the court, which was to ask him if he had an up-to-date skeleton.
Yes.
He honestly misunderstood that to mean he should provide a supplemental skeleton. Having read the skeleton, I'm not objecting to it.
Thank you very much.
Just to notice, if we may, if we could turn to the trial bundle, page 154. Well, 153 in fact.
In the core bundle,
In the actual appeal bundle.
not the trial bundle.
Not the trial bundle. The bundle.
So, core bundle, page 153.
153.
Thank you.
Just having a look at the letter rejecting Ms. Kuteh's appeal. And I just want to pinpoint some of the issues, what this case is about. And it's about disproportionate reaction and the nature of religious speech. But if we go to 154 and paragraph B, following the reasonable management instruction given in April, I always ask patients whether they were comfortable with discussing faith. If they said they would not, I would not mention it. And then 3 paragraphs down, whilst we heard from you that you did not intend your actions to cause offence to patients, we were concerned that you did not appear to recognise that several patients, i.e. those that complained, did not welcome these discussions. And then at the very bottom, under paragraph C,
I think we better have the other sentence from that paragraph.
we also found your position on the nature of these discussions lacked insight and what was an appropriate interaction with patients, including asking patients to sing and giving one a Bible. And we don't detract from that. We do accept this is an imperfect case. It is a case of someone perhaps not appreciating unwelcome comment, but that's a different matter when the correct tests are applied. We are not saying that she behaved brilliantly, perfectly. And that was the point of my supplemental skeleton, that we all hear comments every day, whether it's someone in a Times newsroom expliciting about the Pope, right through to swear words. We live in a world like that. And then just at paragraph C, I'm just drawing the obvious point. It's just after section 20.7 NNC code at the bottom of page 154. We recognise that you may have believed the conversations were consensual, but think this demonstrates lack of judgment on your part as patients are in a vulnerable position. And then I just want to jump to 156, paragraph 3. Ms. Kuteh felt the trust had ignored evidence about her character and her historic disciplinary record. The trust had witnessed statements from colleagues stating that I was a good, hard-working person and good with patients. Another stating that I had a good working relationship, that I was kind and brought a different kind of experience. And mentioning she had one of the managers involved didn't have much concern about the quality of her work. Now, there's a reason why I just want to focus on this, and of course this is a person who worked in this particular trust for 9 years, 4 months, with one incident in 2012, where she 2015, where she gave an incorrect medicine to a patient, of traditional exemplary record. All these conversations on religion took place within a 2-month period in approximately April 2016 due to a number of factors in her life. Just moving on, the learned court asked for the supplemental bundle index, which covered the Nursing and Midwifery Council. Just, if I may, just touch on page 165 of that. 165? Page 43 at tab, page 43, tab 3. And of course, this was a much more thorough investigation than the Employment Tribunal. This was over, I believe, 5 days or so, as opposed to a single day.
Why is that relevant?
Just that it was a very thorough investigation by the professional body responsible.
But the issue that we have to consider is whether at least indirectly consider, is whether the Employment Tribunal erred in law.
That's correct. But I'm just framing it in my opening. I won't say any more on this. If you look, there's some bullet points which they found about her, and you can just see what their findings were. And you may be aware that they put a 3-month condition of practice on her and had a slightly more proportionate disciplining process. That's the only point I draw on that point.
What point?
Well, the point, I'm trying to build a case. This is not a case of some renegade nurse who is irresponsible. She clearly mistook politeness, acquiescence.
But sorry,
Yeah.
the question was simpler.
Oh.
What's the point you want from page 43?
The only point, I just want you to notice those bullet points, that was their
on
summary.
mitigating features.
Mitigating features. Your misconduct arose during a difficult period in your life.
Yeah.
Your next point, your misconduct was limited to a relatively short period of time, set against a lengthy nursing career. No evidence of actual physical harm caused as a result. You've undertaken considerable independent learning and reflection. You have engaged in these proceedings and with the process. You have not sought to minimise your accountability. You have shown genuine and sincere remorse. And that's the kind of person we are dealing with in this case, who is now sustaining severe hardship. In the supplemental skeleton, I had a passage called currents, and I think, and in that I mention that sort of religion plays a very important part in many British citizens' lives, and we spend a lot of time at work, and it's something we all have to live together with in a civilized society. You will hear people say things you don't like. Religious people hear things they don't like. We all the time are confronted with views that we would rather not hear, or we think the person possesses the rankest error.
Mr. Diamond, you'd accept here that his context is very important. These are patients turning up at hospital. They may not wish to be confronted with views. They'll be vulnerable and anxious. Context is all important, isn't it?
Well, that's exactly the case I will be presenting. Religious speech, and as I said earlier, in the workplace, takes place in manifest guises. So does religious speech. Religious speech, for example, could be naked prophetism. If you don't follow Muhammad or you don't follow Jesus, you will go to hell. Religious speech can be comforting, can be prayerful. You can be anxious going into hospital. The trouble with these kinds of cases is that we're totally motivated by complaint. People complain, but there will be countless patients under Mrs. Kuteh's care who will say that prayer strengthened me or comforted my family at an anxious moment. And we say Mrs. Kuteh's motivation in this case was simply to offer comfort. Yes, to vulnerable patients, yes, to people in hospital, but they're chaplains in every hospital, they're religious officials in every hospital, because life and death is a core of our human existence. And then, of course, there's the other extreme, which we recently, my Lord, had a case on, in which matters are quite strongly said. You should not live in that lifestyle, God does not approve of that. There are many, many variants and manifestations of religious speech. But the test is to classify this speech. Was it motivated by animus? Was it motivated by anger? Or was it targeted? Or was it simply comforting? We say it would be normal if someone was dismissed for something, we applied Article 10. You would have many councils say freedom of speech is an inherent good. Our society should protect freedom of speech. It's the search for truth and debate state, as what makes society. I simply say Article 9 uses the word prostitutism instead of freedom of expression, and all that article proselytize means, it means simply in Greek to come over. But what we submit is that what is integral to free expression under Article 10 cannot simultaneously become a threat or a concern because it falls under Article 9 and has a lex specialis rather than a lex generalis. And there's a reason why there's a lex specialis for Article 9, with the inherent additional test of inappropriate and appropriate and intimately linked, because this court would not hesitate to take an Article 10 approach if it was a pure free speech case. But since we're in the realm of Article 9, it is a particular species of case, speech. And it's something recognised in all societies as something particularly important. I mean, even our Human Rights Act is Section 13 and Section 12, singling out free speech in various categories and religious conscience as particularly important. And of course, the American First Amendment does exactly the same. It's their first freedom. And the reality is, religious speech is a species of speech that has an elevated protection.
Mr. Diamond, forgive me for interrupting.
Yes.
You've taken us straight into the Human Rights Act
Yes,
and Article 9.
yes,
But this is an unfair dismissal case.
yes.
The Employment Tribunal doesn't have jurisdiction. You can, if you want to, you can, in fact, launch a cause of action directly under the Human Rights Act. That would have to be in the appropriate court, which might well be the county court. This happens to be a public authority, so in principle, there could be a cause of action. But the fact is that that's not the dispute that we, in fact, have before us.
No, well, perhaps we then ought to first have a brief look at the judgment of the learned judge at the Employment Tribunal stage. I think that's
Then we might turn to your grounds of appeal.
Yes, we might. I'm just painting a slightly a background. I apologise.
Not at all. Let's look at the judgment and then let's go come to the grounds of appeal. We have the judgment.
Yes. Well, the learned judge deals with an unfair dismissal case. He notes at paragraph 31 the position of the defendant in this case, or the claimant in this case. 31, third bullet point. She admits she spoke to patients, stated that she was not denying that she had discussions about religion, but she did not initiate them.
She did not always,
initiate, not always initiate them.
And
Yes.
ergo, by definition, she was admitting that she did initiate some discussion.
Yes. I'm accepting that. We're not accepting that this lady's perfect. We're accepting this was a human interaction with patients.
So please do read what is in
I
there
apologise.
correctly.
It then, if I go back to page 23, back to page 54, paragraph 23, we have the instruction on the 11th of April 2016. The matron, Miss Gill, spoke to the claimant to express her concern that the claimant had been having religious discussions with the patients she was assessing. She told the claimant that such discussions were inappropriate and should not take place in the future. And then this is a prohibition on her having all religious discussions. Then, just touching at paragraph 36 of the judgment.
Hang on, it's also right. We must take some care when we're reading things to read them in their full context. If you say at paragraph 23, she told the claimant that such discussions were inappropriate and should not take place in the future. The claimant assured Ms. Gill she would change her ways. Ms. Gill then writes a letter the next day explaining the sort of conversation that she had in mind. I think it's quite important in a case like this that we get the context right.
I understand, my Lord. It's not an attempt to sort of cloud anything. We accept that Ms. Kuteh probably mistook politeness by patients or acquiescence by patients as a form of consent. But I just draw in her argument. Her case would be if they said, please stop, she would have stopped. But many people, out of politeness, may not say that. But there's one thing being slightly insensitive, and there's another thing being losing your livelihood in the balance.
Well, anyway, the last paragraph of that letter, paragraph 23, is after the discussion. You gave me the assurance that you will not engage on the topic of religion unless a patient asked you to.
Yes.
One assumes the letter is accurate.
The letter is accurate.
Thank you. Sorry, I interrupted you.
And we face the difficulties of this.
Yes. Where do we go from there?
Well, the point I'm just drawing at this stage is the paragraph 36. It goes over to 57, 56, 57. She presents her case. I just draw the attention. The learned judge, employment judge, realizes that she felt compelled by her passion to comfort patients. Previous paragraphs that are too unwell to talk about religion, some of them, asserted that she didn't initiate the discussions, accepted she'd given a patient a Bible because they had been discussing religion. She gives her case. That's the point I draw, and again that's repeated on the appeal notice.
The next bullet point said she recognised she was in breach.
Yes.
And then effectively what's said, as I read it, is matters of mitigation. But in the last bullet point, she recognised she had been imposing her views.
Well, yes, well, obviously that, I'd like to address that perhaps a bit later in submission, but we would say an employee accused of things where they think they have done something wrong will of course want to, save their job, and will say things in that environment. That does not mean that the employer and the court should not fully consider the requirements of Article 9. What this case is essentially about is simply some people, and I say some, were offended by her religious speech. And there's some people who are going to be offended by religious speech no matter what you say, because they may be aggressive.
That's not what this case is about. This is an unfair dismissal case. And this is now an appeal.
Yes.
Which can only lie on a point of law.
Yes.
From a judgment of the Employment Tribunal that the dismissal was not unfair.
Yes.
Now, if one goes back, for example, to the particulars of claim attached to the original Form ET1, which is the pleaded grounds that the Employment Tribunal was confronted with.
Yeah.
That wasn't how the case was pleaded initially. There was a reference obliquely at paragraph 18 on page 80 to Article 9, which was simply to say that the NMC's code must be interpreted in a way compatible to the employer's rights under Article 9.
Yes, well...
So why is the Employment Tribunal to be criticised?
Well, the Employment Tribunal
deals with it as an unfair dismissal case, which is what it was.
Yeah, well, they did deal with an unfair dismissal case. Of course, what is reasonable will depend on whether it's in conformity with I would submit, the European Convention, and it's not a difficult case is to stretch the term reasonable to include convention requirements. But what is the guidance code by the NMC, of course, is in conformity with the convention because it applies, erroneously or accurately, the convention requirement of the requirement on public bodies to draw a distinction, or the court, to draw a distinction between appropriate and inappropriate speech. So, by definition, some speech is appropriate, and that's exactly what Article 9 is. Now, the judge rejects that analysis in paragraph 71. He just says, you can act on a complaint, and you can silence someone totally broad-brushly, which we would say is an unreasonable order. At paragraph 71, he says, I do not accept Mr. Strolios' position that consideration of these issues required a deep philosophical inquiry as to what was precisely meant by the word inappropriate.
Well, I'm sure he's right about that. A professional code does not normally require a deep philosophical inquiry.
Well, the problem is, it doesn't require deep philosophical. I mean, I think that was more sarcastic and dismissive than the requirements under law to actually say, the code itself says that is appropriate religious speech.
Okay,
A mere complaint doesn't suffice.
sometime, Mr. Diamond, as my Lord observes, we aren't having a freestanding debate. Hang on, bear with me just for a moment. We're not having a freestanding debate, interesting though no doubt would be, about Article 9.
No.
We have to decide whether you can make good a ground of appeal.
I agree with that, and that's what I'm trying to do that. Maybe slightly gilding the lily before I get to the lily, but I am seeking to say...
Sometime we need to reach...
Well, this is the first point then. The first point is, of course, the learned judge did not consider the requirements of the code and clearly accepted the employer's position that a mere complaint, because someone was irritated by the conversation, was inappropriate. And we say that's not correct, because some people will object to religious speech, and we have to analyse what is appropriate and inappropriate speech, and people may be somewhat insensitive. I don't purport that Ms. Kuteh has all the skills, but if someone doesn't tell her to be quiet, she may not get the right end of the stick. The other point is, the learned judge, Article 9 was a relevant part of the Employment Tribunal decision, and it's unlikely not to be, since it was clear religious speech.
I'm sorry, just before you move on to that point, and I don't want you to lose sight of it at all, but if we just go back to the instruction which you reminded us of at page 54, paragraph 23, and the assurance that the appellant then gave to her employers as recorded in the final paragraph of the letter of the 8th of April. Then what the Employment Tribunal does is make a number of findings of fact as to what occurred subsequently in May and June 2016 after those assurances have been given. And those incidents are summarised, for example, paragraph 24.1 and 2, but also on the next page at paragraph 28, which is the incident on the 20th of June. Now, what is your client's case about those incidents? She having given those assurances, she then did the thing that found as a fact by the tribunal. You may disagree, but that's the findings of fact by the tribunal. These events occurred. Now, were these events appropriate or inappropriate on your submission?
On our submission, we don't know whether they were appropriate or inappropriate, because they've never been investigated and there's never been any inquiry onto it. All we know is there was a complaint, and we accept there was a complaint by an irritable patient. But the question whether they were appropriate or not appropriate was not found out. And at the NMC, I think one patient did turn up at it, and that was an issue. That was one was found, one incident. The point we say that a blanket ban on speaking about religion was clearly an unreasonable instruction under the European Convention, and it needed greater scrutiny on behalf of the employer. An employer simply can't say no more religious discussion of any sort, and then dismiss somebody on a mere complaint that's uninvestigated.
Mr. Diamond, read the words, please, again. Paragraph 23. An assurance was given by your client that she would not engage on the topic of religion unless a patient asked to. It wasn't an entire blanket ban, but it was a very clear instruction, which, as my lord has pointed out, on 3 occasions very immediately thereafter, on the 16th of May, 31st of May, 20th of June, your client failed to obey. So what is your case on that, what appears to be a deliberate disobedience to a clear instruction?
Well,
cutting to the chase, we can go around the houses, as you have so far on Article 9 and so on, but we really need to know what your case is on the core aspect of this case.
Well, the core aspect is twofold. The first core aspect is simply the national professional guidance, appropriate, inappropriate. That, okay, there may be a question here on you may say on a clear instruction. I beg to differ on the force of that instruction, but the professional guidance code says appropriate and inappropriate, doesn't simply say, doesn't categorize it, there's too many versions of speech. The second point is, if Article 9 is engaged, there's simply a proportionality part to it. It's not enough for the court to simply say that there was something that could have been perhaps restrained by 9.2, because we do accept, of course we accept, that there's a legitimate aim in preventing persistent, unwanted speech on religion. There's no legitimate aim in having a religious-free zone at work or a quasi-religious-free zone at work. And in this case, the employer overreacted, and the penalty is quite clearly excessive, which is the convention organs takes that into account. And we can see it's excessive because even the professional body wasn't so extreme, but to be dismissed by the NHS, which is effectively a monopoly employer in this field, has very serious implications. And that has it's not just Article 9, it's obviously her family, her welfare, and there's got to be a proportionate penalty. That if we could have got the convention in, at least Article 9 or even Article 8, we would have had at least a proportionality check on it. And clearly there was a less intrusive mechanism, because the professional disciplinary body thought there was a less intrusive mechanism, and she's now having to work in various private care homes at the moment, but not exercising her profession.
I'm sorry, Mr. Diamond, that cannot be the test in employment law. It's well established in authority dating back more than 40 years that the question in an unfair dismissal case is not what other people would have done.
Yeah.
It's not what the tribunal or this court might have done. It's whether the decision by the employer to dismiss fell within the band of reasonable responses. So, showing us that some other professional body decided after some other inquiry to impose a lesser sanction, I'm afraid doesn't really help on unfair dismissal.
Yes and no, my lord, if I may. I think this is why, firstly, of course, the tribunal has to approach it correctly. So we say the issue of appropriate, inappropriate speech was simply not addressed, and that would have had an impact on any employer that we can only speculate about. But the second point is, and I don't want to sort of do any challenge to the Employment Rights Act, and I'm sure in general the Employment Rights Act tests do suffice to satisfy. We simply say in this case, like Ferendo Bobes in Spain, it's disproportionate, the sanction, for a violation of a convention right. And we have our obligation, as much as possible, to read our national legislation as far as possible in conformity with that, and that is not difficult. unreasonableness and penalty go hand in hand.
Well, I understand how you put the case, and that's, I think, ground 2 of the
Yeah.
appeal. But in relation to ground 1, can I just ask you again, insofar as the submission is that the Employment Tribunal failed to appreciate the distinction between appropriate and inappropriate conduct, if we take the incident described at paragraph 28 of the GT judgment, page 55, one is not, as my lord said, we're not having an abstract discussion here, we're having a discussion on the facts of this case. What is your client's case in your submission about the appropriateness or otherwise of the incident described at paragraph 28?
Well, we're not saying she had a right to do that. We're saying that was, we don't know the circumstances of what happened. It's clearly quite excessive. I accept that. The person, it was a short period, as recognised, where for a variety of reasons she was a bit proactive. And we, obviously the person went along with it and then subsequently complained. And we accept that. And we're not saying she has a right to do that as such. We're saying she made mistakes. We're saying we all make mistakes. We sometimes ask the wrong question. She may have been insensitive.
I'm sorry, Mr. Diamond.
Yes.
That appears to be a different ground. But the ground you're addressing at the moment is that you say there's an error of law because the employment judge failed to understand the distinction between appropriate and inappropriate conduct. Now, I ask you again, please, is it your submission that the incident described at paragraph 28 was appropriate conduct or not appropriate conduct?
Well, I think our submission would be on that. I mean, I know the reality of it, but it may have been, if you had investigated, which they didn't do, the individual may not have objected.
Hang on. Sorry. My lord puts to you paragraph 28. That's a fact finding. Those are the facts. Without any more ado, my lord's entitled to ask, and for that matter, so am I, as to whether you say that was appropriate or inappropriate. We don't need a further investigation, those are the facts. What is it?
Well,
Whatever flows from it, let's just start with agreeing or disagreeing on the facts.
well, I accept they are fair, but if you could, they are. It is on first blush going too far. We accept that, but if you look at 28:4, he just says he asked him to sing Psalm 23.
Yeah.
He was so astounded. He sung.
Yeah.
And he went on to describe the whole instant encounter as very bizarre and like a Monty Python skit. That
Yes.
speaks volumes, doesn't it, about the circumstances in which that particular patient found himself with your client, who held his hand, wanted to give him the Bible, wanted to sing Psalm 23.
Yes, and it does speak volumes, but it also shows, I would suspect, a slight bemusement by what took place. I mean, people, it's arguably, yes, it would seem very bizarre, it's gone too far, but the question for us is, the court still has to determine which is appropriate and inappropriate, and some maybe, some might not be, and there's still the proportionality analysis when Article 9 is engaged. So if it was one incident or two incidences, and some of these people did not turn up to give evidence when they were given an opportunity to do so.
That's ground 2.
That's ground 2.
Mr. Diamond, to answer my Lord's question, this was, on any view, plainly inappropriate.
Well, I won't. All I'm saying in this case is that was plainly inappropriate. But we have to. That is one incident then, not 8 incidences, and clearly the question of reasonableness goes into the proportionality test. But we're not saying that we're not saying that that appropriate or inappropriate, or Article 9 gives Ms. Kuteh the right to do or say whatever she wants. What we do say in this case was she misread the situation. You may be surprised how badly it could be misread, but she wanted to comfort a patient and she wanted to encourage them. And the patient went along with it without asking her to stop. So she lacked a degree of sensitivity and perhaps not realising that people were uncomfortable with it.
Let's assume, to move on, let's assume that the facts described at paragraph 28 of the judgment constituted inappropriate conduct. Whatever you say about it, let's make that assumption. Where do we go from there?
Well, what we go from there is that there are incidences of inappropriate conduct. What there isn't permissible is a blanket ban on religious speech, and some of those incidences were miscalculations which have ceased. So we say the dismissal was wholly disproportionate, it was unreasonable, and the learned judge may have come to that conclusion if he hadn't accepted these versions of events without a more further detailed inquiry or the balancing act to be done.
These are findings of fact. What's wrong with them? Assuming we have the power to look at that.
Well,
which I'm not sure we do.
Well, I think what we say, the correct approach should have been, clearly there were some very strong complaints, but the correct approach should have been to inquire on the circumstance. Of course, prima facie, yes, it is bad. But if Ms. Kuteh said, well, the individual acquiesced to it, the individual never asked me to stop, I thought I was comforting him.
Some man waiting for a serious operation. It's not, the test can't be whether he actually said, getting over his surprise, please stop. Different people will be more or less abrasive or more or less courteous. But let's just look at the facts, because I think there are three, speaking for myself, there are three findings. Paragraph 20, we start off with the discussion with Miss Gill, and at paragraph 23 of the judgment, after the discussion you gave me the assurance you will not engage on the topic of religion unless a patient asked you to. And we've agreed the letter's accurate. So that's the assurance that is given. Paragraph 24, can we just look at that, please? 24.1. This is within weeks of the assurance. Fact, a patient complained the claimant had given her a Bible and that it said she would pray for her. The patient then returned the Bible to another member of staff. 24.2, a couple of weeks later, the patient complained the claimant was preaching at her and made her feel uncomfortable. And then, of course, the incident described at paragraph 28. Now, there's just seems to be fact findings. What's there to investigate further, if I can put it crudely?
Well, we simply say that's a mere complaint. It's not enough to say you can't speak, you have a blanket ban on religious conversation.
It's not with respect to blanket ban. 28 doesn't get near a blanket ban with respect. 24.1, presentation of the Bible, was that asked for? The patient requested? The patient asked for a discussion about religion?
I'm saying these matters are not, it's going to sound a bit, there are two cases the other way I presented.
Yeah.
One was an employer blasphemously swearing Jesus this, Jesus that, and the person found it very objectionable. Another person was a Times editor going on apparently about I think it was in the context of Pope priest matters, and he sort of gives explicit. People find conversations offensive. Doesn't give, and people generally don't react to every conversation. You have to live with it.
That's why my Lord's point early on is, with respect to so significant context.
It is context, but my Lord, if someone gives you a Bible and you say thank you for the Bible and then throw it in the bin when the person walks away,
that's one reaction.
Yeah, there's one reaction. I think in this case, I think it says she gave it to another nurse immediately. That is not a matter of legal consequence. In fact, the employer, in such a circumstances, is adopting a form of animus to the Christian Act. All someone has done is said, would you like a Jane Eyre novel? Would you like a Bible? I thought you were interested in it. I'm giving you this book. You go, thank you, and I put it in the bin, or you take a leaflet, or whatever you do. That is normal human interaction. And the employer needs to not overreact because the subject matter is religion. That's the problem.
Mr. Diamond, the problem is, speaking for myself, that you are not, with respect, dealing with my Lord's questions. This was not a mere conversation or a meeting in the street or the pub. The context of this was a nurse whose job was to fill out a form of patients arriving at the hospital ready to be admitted.
Well, another version of the context is these are very worried patients. We have a compassionate, caring nurse who's anxious for their welfare and is trying to comfort them. Maybe
who had given a clear assurance after being brought in because of previous instance that, quote, she would not engage on the topic of conversation of religion unless a patient asked. And within a very short space of time, cutting to the chase, there were 3 significant complaints,
and
which on their face, as my Lord had said, require no further investigation because the facts are clear. So what we need to understand is what is your case, your submission about that core aspect of this appeal?
Well, the core aspect of that thing, that obviously that is disobeying of an instruction. The question would be
correct.
Whether that is a reasonable instruction and whether that instruction was, and whether Mrs. Kuteh was entitled to stand back from an instruction that was, we submit, unreasonable or not relevant to context. The whole purpose in our submission, to cut it to a chase, you can discuss religion with a patient, but you should make sure that it's welcomed and sensitive, and it's a positive engagement of that conversation. But in that, she made some errors in a 1-month, 2-month period, and we accept that. I mean, but the offence was not disobeying a management instruction. Her offence was to be somewhat insensitive, perhaps not recognising that the person didn't want to engage in that.
Okay, but there are a lot of points you've merged in that summary. I've got a few questions, I fear. When you say, was it a proper instruction, I'm struggling, it may just be me, but I'm struggling to see how that fits into ground 1.
Well, it fits ground 1.
I may struggle a bit to see how it fits into ground 2, but I certainly struggle to see how it fits into ground 1. Ground 1 deals with the distinction between, the judge failed to consider the distinction between inappropriate and appropriate. Now we've taxed you a little pedantically, perhaps, as to your case on this, but we need to know it. And I'm struggling with ground 1. I also detect, and maybe none the worse for that much of your argument is a plea in mitigation. But then the question arises as to our jurisdiction. So,
Well, in terms of plea 1, all we simply say on that is that there is appropriate and inappropriate discussion of religion. That task has not been completed by anyone, by the employer or by the learned judge. It's simply taken as a given. If someone complains, that complaint is taken
well,
as
you've said that.
Yeah, so that's on
So
point.
is that it on ground 1?
It is on ground 1. I say that's in conformity with Article 9, but yeah.
Then we'd better get to ground 2, as my lord wanted more on ground 1. Shall we move to ground 2?
Yes.
I'm
Well-
not stopping you, but I
No,
can't
no.
see anything else on ground 1. So, ground 2.
Ground 2.
Page 27 of the bundle.
Well, in that case, if I may,
Yeah.
let's perhaps, if I may just go
You
to
want
a couple
attack-
of authorities.
Well, just help me, I may be being obtuse.
Yeah.
Paragraph 84 of the judgment is what's in your sides. Let's have a look at that. Then we'll worry about authority.
Well, just to say, so to draw your attention to the full, paragraphs 51 and 52 mention Article 9 and quotes Article 9 along with Section 3 of the Human Rights Act. That's paragraphs 51 and 52. And then paragraphs 82 and 83
Yes.
And he relies on the case of Shondell and Liverpool City Council. We say that's incorrectly decided, and we say Article 9 has a different requirement which he failed to consider.
What's the different requirement?
Sorry, yes.
Forgive me.
No, no.
So what's the point he failed to consider?
Well, Shondell forms part of a series of British cases which simply say focus on the discrimination point and the reason why argument, and the employer's motive could be wholly, I treat everybody the same if they...
You may be right that that's what the underlying case law says, but the statement of principle, insofar as it is that, in paragraph 83, is not a discrimination point at all. The
No.
employment judge here is making what he says is the important distinction between the claimant being prevented from inappropriately proselytizing her beliefs as opposed to being prevented from manifesting.
Yes.
In a sentence or two, can you help me, please, with why that is wrong as a matter of law?
But the correct analysis would have been an Article 9.2 analysis, and then all the factors of necessary in a democratic society, the sanction of the penalty, whether the reasoning is sufficient, relevant and sufficient reasons, whether convention standards have been applied, would have been applied. And our case in this is far too draconian. You have to recognise that Article 9 is engaged, just as it was in Fiorenzo, Bobo or whatever, and the penalty can breach the convention.
It's not directly engaged. You have, if you want to pursue it, available to you a cause of action for breach of the Human Rights Act. That's not actually the cause of action that was before this Employment Tribunal. So why is an Employment Tribunal being criticised for not adjudicating in those sorts of terms on a cause of action that wasn't even in front of it? But secondly, in any event, what Mr. Justice Chowdhury held in substance was that in substance, bearing in mind that the employment judge is not writing either a dissertation or even an exam paper, in substance, this employment judge did an Article 9 analysis, because, stripping it to its bare essentials, there was inappropriate proselytising, and there were, on the other side of the balance, important interests, including the rights of others, in particular the patients. And really, isn't this a case where it doesn't need a great deal of elaboration to see where the balance was being struck? And that's exactly what the employment judge earlier said, when he said that the decision to dismiss fell within the bound of reasonable responses. That's the balance.
Well, we say to that if Article 9 was engaged, the court has to do relevant and sufficient reasons in conformity with Article 9. It has to do a full balance of the convention rights and engagement. There can't be some form of unspoken deference that they accept by the employer. They do have to critically engage in the employer's position and the balance of effect, not just on the delimitation of Article 9 rights in the workplace, but also the personal consequences of a summary dismissal of this individual. And that did not take place, and the balance would have been very different. And
forgive me, it did. That's exactly what an unfair dismissal case is. That the employment judge studiously went through all of the elements, the fairness of the investigation. 62, he says, entirely fair and reasonable. Fairness of the hearing. 67, he says, can't find anything to render this hearing in any way unreasonable. Honest belief, he deals with that. Sanction, he deals with that. And 76, he concludes overall, in all the circumstances of the case, the decision to dismiss falls fairly and squarely within the band of reasonable responses in a case such as the present. That's the Section 98 inquiry he had to conduct. In substance, bearing in mind Article 9, which he expressly cites and then refers to at 82 to 84, hasn't he done the balancing exercise?
well, it has under national law, but of course we would say the balancing exercise as to what is reasonable has to be done under convention law, convention principles.
Sorry to cut in. When one looks at the distinction the judge drew, which Mr. Justice Chaudhry returned to in paragraph 12 of his ruling, what's the distinction anywhere with Article 9? The distinction the judge is drawing at paragraph 83 is between inappropriately proselytizing and manifesting beliefs. Now, speak for myself, I struggled. Let's bring Article 9 out of the closet. But when we do, isn't that the very distinction that Article 9 itself draws? As Mr. Justice Chaudhry observed, paragraph 12 of his judgment. That's why I'm struggling with it.
Yes, well, I think what we say is...
It's all terribly interesting, but I'd like to see what the error is.
Well, we say it does do, and there simply is an error. We're not saying that it's not, if an Article 9 analysis had been done, and if there had been a full inquiry into what was appropriate and inappropriate, accepting some form of discussion on the nature of the speech, this whole judgment is devoid of any discussion on the nature of speech. I mean, I'm guilty of this sin, but when I commenced, I slightly went on about the different manifestations of speech, and some people don't like it. But what is missing in this judgment? Was there persistent, harrowing, clearly unwelcome speech? Was the speech animus and angry to the patient? Did the patient acquiesce? Did the patient reply and welcome it? Should the patient in that condition have objected to the speech? What about the fact the patient's got an operation coming up? What about the fact there are misunderstandings? All these queries would have to be taken into account, as well as sort of some of the principles of it, that religious speech is no different, as I said, from any other speech, and there is a risk in society. People always, as I said, take offence and don't like religion or don't like Brexit or Remain. We don't want the conversation.
Well, lots of us take offence at lots of things.
Yes, and you get on with it. If someone says the effing Pope, you put your head down and get on with your job. You don't start trying to get people to lose their jobs. That's life. So what there needs to be is analysis of speech conditions. What was the nature of the speech? What was the response of the speech? Was she persistently continuing in speech? What was it? What was actually inappropriate about it? Was there anything appropriate about it? Is the person really just doesn't like the content of the speech? Not the manner of it, it's actually the content. And why didn't the person tell her to just be quiet and get on with her job? Maybe the person couldn't. It was an 87-year-old and, well, couldn't do it. But this is what we say should have been done. Speech is generally protected, and religious speech is specifically protected because it's a special species of speech, and it's a speech that not only has the Article 10 protections, but it has an additional inappropriate protection. And those two factors the judge should have addressed. He may have come up with a finding, but they are, I mean, there's no way you can give a Bible to a patient to get him to sing a hymn and be that insensitive and be a nurse, no matter how caring you are. But there may only be 1 or 2 complaints as opposed to the 8 in that period. And the correct, less intrusive penalty would be to move her, put a supervisor for 3 months, is what happened ultimately. That is what we say would have happened. And there's no doubt that form of analysis of what kind of speech is permissible has not taken place.
Speaking for myself,
Yeah.
Mr. Diamond, nothing you've said in the last 5 minutes, to my mind, addresses the point that we were putting to you earlier, the core of this appeal, which is very simple, that your client appears on the face of it to have disobeyed a clear instruction given to her that she would not engage in this, in any discussion of religion unless asked. And there were 3 immediate complaints. And what you need to understand is what is your submission about that core aspect of this appeal.
Well,
It's nothing to do with the nature of the speech or any of those aspects.
yes, but that's simply a knee-jerk reaction, we say, by management. We're not saying it's not understandable, but we're saying it was a knee-jerk reaction receiving the complaints. The management weren't sure what the regulations said. They should have been, that the NMC does have provisions for appropriate and inappropriate speech. They should have gone further to it. They gave a very blanket restriction, and we've still got, so we say that was too heavy-handed and unreasonable. It was an unreasonable instruction, and because it wasn't in conformity with the national codes, and it's still, if Article 9 is still engaged, and it's still an extremely harsh sanction.
Yes. So it comes to this. I'm not putting words in your mouth, but I think we may have covered the ground. This was a disproportionate reaction by management. There had not been the necessary inquiry, that's your ground 1 point, as to inappropriateness. And as to ground 2, they omitted the judge omitted from his consideration the the Article 9 balancing exercise.
You did.
That's your case.
I think it is my case. I just said one point, though. We do think that this type of speech...
I'm not saying I'm agreeing with it.
No, I know. I think I'm more
Just trying to
fearful
make
you're
sure.
not, if you want to know the truth. But
I'm just making sure I've understood it.
yes, I think what I would say is this. There is a decision to be had on the nature of speech. It's coming up again and again, these cases. I find this offensive. I don't like it. It's the content of it. It's religion, it's sin. But this speech is fine. You know, President Trump's a moron. That's absolutely fine. We need a debate on speech. It's not some speech is okay because that's what the culture tells us, and some speech
I have a
isn't. So,
feeling my
yeah.
Lord Justice Singh might say to you, well, that's fine, but is an appeal against unfair dismissal the right forum for that debate?
well, we would have said that should have been done by the trial judge, and that was a complex, not a philosophical.
Well, then my Lord would amend to say, is an unfair dismissal claim hearing the right forum for that debate?
Well, it is the correct forum for that debate if it gets to the Court of Appeal, and the learned Court of Appeal can
Anyway,
put parameters.
have I
down.
missed anything in my
No, I
summary?
don't think you missed anything. I think that's it, my lord. Thank you,
Mr.
I'm
Diamond, thank
obliged.
you very much. Thank you very much, Mr. Diamond. We'll rise briefly.
Space persons, but I normally sort of can't stand food as I'm in a sort of 28-star restaurant. And I had this can of fuel, and it was absolutely disappointing.
Does it fill you up?
Actually,
That would always be my
I'm just trying to lose weight now.
Yeah, exactly.
Well, I suppose you're just going to say ban reasonable response and blah, blah, blah.
We'll see.
They're just out. They're
just gone out.
debating whether to throw my case out. You just missed the funding.
We've just missed the punchline.
Well, he may come back. If he stands up, I've achieved first base.
I think I might sit down.
Baroness Hale, you'll save us. Yes.
I'll let you appeal notice capital. I'll fly. Yeah. Enjoyed it.
Is that